No,
Soon.
because I can't hear you.
Now, yeah.
We can hear you, Lois.
Greetings to you all.
Let me try to come back in.
Good afternoon.
Hello, Michael from Mauritius.
Hello, Robin. I think you win the geography award.
Well, actually, hello from the Bahamas.
Yeah.
You in the Bahamas?
Oh, wow.
I think I've got the altitude award, Michael.
Well, you've been high oftener than many people that I know. That's true.
I confess, mea culpa.
Yeah.
All right. I think we're going to go ahead and start, but we did make this a Zoom meeting so that we could have that kind of informal interaction, and we'll find ways to continue that throughout. Greetings and welcome to the celebration of Michael Tigar's newest book, Sensing Injustice, A Lawyer's Life in the Battle of Change. And I have a copy of it behind me. It'll stay there, all earmarked. The book was just released by Monthly Review Press and is available for purchase online. And Sarah Eliason, who you all have been getting messages from, is going to put in the chat information on how you can get the book. And also Monthly Review Press just decided to provide a coupon code that will allow you to get 30% off and a free ebook. So it's a deal only for you all. And we'll put the information there later in the program too. My name is Karen Engel, and I'm a law professor here at the University of Texas. And I co-direct, along with English professor Neville Hode, the Bernard and Audrey Rappaport Center for Human Rights and Justice. It's the Rappaport Center's great honor to host this event today, along with the Briscoe Center for American History. Michael Tigar taught at the University of Texas for 15 years. Well, I should say formally for 15 years from 1983 to 1998, but has also been teaching informally here every so often since then. We're extremely grateful, as many of you know, that Michael Tigar entrusted the Rappaport Center and the Briscoe Center with his papers. Some of you were in Austin in person for the terrific event we held in September 2018 to launch the website with the papers. And I asked Sarah also to put now a link in the chat for that, so you can have all of your chat links open and then look at them after the program's over. In case you don't know about the archive, I want to make sure that you know where to find it. We also, so the archive has his papers. It also has a recording from the event in February in 2018. So if you weren't there and would like to see it, you can watch the recording on the website. And I'll also say it's very much a living archive. Michael keeps sending us things, and this event will also be a part of it shortly. There are many treasures in that website and in Michael's papers, but in case you don't have time to read them all, he has distilled much of them in this book that we're going to talk about. So maybe I will pick it up so you can see. It's a mere 500 pages. So that's pretty good, a whole website, 500 plus pages. And he calls it a memoir, but as you will hear in a bit, memoir does not really come close to capturing what this text represents or what it does. Now you'll hear about Michael and his legendary career today. While many quite correctly know Michael Tigar as a high-profile defense attorney and one of the finest litigators in the country, that label, just like memoir doesn't begin to encapsulate his life work. He's a relentless fighter of injustice, not only as a human rights lawyer, but as a teacher, scholar, journalist, playwright, and comrade. And importantly, he has a keen sense of the deep structures of injustice and of the ways that they defy national boundaries. And the people in this Zoom room don't need to hear that from me. You've already got a sense of it if you were there when we were starting a few minutes ago as people were saying where they were coming from. You come from all over the world today, North America, but also Latin America, Europe, Africa. There are even some people joining us very late at night from South Asia and in the wee hours from Australia. For all of the downsides of Zoom, and there are quite a few, it has facilitated an international gathering that is well deserved here today. So again, welcome. Now, Michael is also deeply aware of the possibilities and limits of law in addressing the injustices he senses. And so it's not surprising that people have joined us today also from many walks of life. You are judges, lawyers, law professors, and law students, but you're also humanities professors, activists for many, many social justice causes, journalists, and more. Many of you appear in Michael's book, many by name, and I hope we'll have a chance to hear from some of you in the course of our time together today. Before I give you some basic info on our program and introduce our very distinguished panelists, I do want to recognize a few people who play starring roles in the book who are here with us today. So first of all, Michael Tigar plays a very starring role, and a number of his family members are with us as well. So they are his son, Federal District Judge John Tigar, his daughters, Dr. Catherine McQueen and Elizabeth Tigar, and his wife, who has also been a longtime law partner and collaborator, Jane Tigar. Join me in offering them a virtual applause. I see Rob Owen already started that, so you can do it however you like, with or without the gadgets that Zoom offers. Now, let me say a quick word about the program. In UT Law School Book Fest style, so this is something we do for faculty when books come out, we've asked one person to give a view of the book as a whole, and then along with 3 other people to provide short comments on some aspects of the book before having Michael respond however he likes. And then we'll then open to the audience for questions. So some quick Zoom etiquette and process matters. I know some of you are new to Zoom, and some of you are watching on YouTube, and I'll say something about that too. I would like to ask everyone when they're not speaking to turn off microphones. It looks like most of you have done that. I want to encourage you all to use the chat function, and I see some of you are doing that already, if that feels comfortable for you. You can add your own stories, you can comment on things that other people say. Not all of us are good multitaskers. I'll speak for myself. I can't pay attention to the chat and what people are saying at the same time, but a lot of people are very, very good at it. And in any event, it'll be very nice for us to have for the record. If you have questions you'd like to pose to the speakers or Michael, I'd like to ask you to wait until the panelists are done speaking. And then you can either send them to me in the chat for me to read out, or if you'd like to speak, just raise your virtual hand. And you can raise your hand by going to the bottom of your Zoom screen where it says reactions, and then click on the bottom, on the button at the bottom that says raise hand. If that doesn't work, or you can also just send me a chat through the chat function and say you have a question you'd like to ask. If you're watching on YouTube, feel free to ask questions there as well. We have a student who's monitoring the channel and will send them to me. So it's now my great pleasure to introduce the panelists to you in the order in which they will present. Because you have relatively extensive bios of them available from the website, and Sarah's going to put those up for you again, and because we want to hear from them soon, I'm just going to say a quick word about each of them and their connection to Michael. In general, here's what you should know about this group if you haven't detected it already. You'll hear from a lawyer, an historian, a judge, and a poet. I'm quite certain that it will become clear to you as they speak why Michael's book demanded that range of commentators. So the lawyer. First, we'll hear from Jennifer Lauren, who is Wright C. Morrow Professor of Law at UT. She specializes in criminal law and procedure and has written a number of very important articles, including on policing the police. Although she came to UT long after Michael had left, she knows him from her time as a student at Columbia Law School, when she worked with him on the Lynn Stewart case, which I know she'll discuss. She has also taken on the task of giving you an overall sense of the arc of Michael's memoir. The historian, I feel like you all should all grow on the screen or something as we say this. The historian, drumroll, activist and scholar, Roxanne Dunbar Ortiz will speak after Jennifer. She's Professor Emerita of Ethnic Studies at California State University in Hayward. She has received numerous awards and published a number of very important books, particularly on Indigenous sovereignty. Her most recent book, which will appear this summer, is entitled, quote, Not, quote, a Nation of Immigrants, Settler Colonialism, White Supremacy, and a History of Erasure and Exclusion. She and Michael have traveled in many similar activist and academic circles for years, and they've each written reviews of the other's work. The judge. We will then hear from the Honorable Patrick Higginbotham, Senior U.S. Circuit Judge for the Fifth Circuit Court of Appeals. He has been a judge for most of his legal career. Indeed, at the time he was appointed, he was the youngest judge sitting on the bench in the country. During those same years, though, he's done a lot of other things. He has taught at a number of law schools around the country, and he's published extensively in law journals. He and Michael met just before he became a judge when they were co-counsel in a criminal case in 1975. Since that time, they've worked together in several contexts, most recently in training counsel in capital litigation. And then the poet. Roger Reeves is Associate Professor of English and Creative Writing here at UT. He has received numerous awards for his poetry, which can be found in his book, King Me, as well as in many journals. And in addition to teaching creative writing, he teaches courses on Blackness and American imagination. He and Michael encountered each other when, during the launch of Michael's papers, we asked Roger to read the lines of Clarence Darrow in one of Michael's plays. They've stayed in touch, and he will talk to us about Michael's storytelling. Now, by the time we get to Michael, he will have been thoroughly introduced. So with no further ado, I now turn the program over to Jennifer Lauren.
Great. Well, thanks so very much to Karen for the invitation to be a part of this extremely exciting event. And of course, to Michael for providing the basis for the occasion with this important and riveting book. I was saying earlier, I so wish that this were a day-long symposium, because in preparing for today, I just imagined dozens of conversations that I so wished to have to sort of drill down on the events described and sentiments conveyed in this book. And hopefully someday we can sit down and have those conversations. But we don't have a day. We have 90 minutes, and I have only 15 of those. And in that time, I have the task of conveying the whole of this book to you. So how can I convey to you the experience of reading Michael's book? Well, I can start with the basic attributes. As Karen said, it is a hefty volume, some 500 pages, 17 chapters. They begin chronologically with the early years of Michael's life, and then they shift to being organized thematically, according to the immense range of legal issues on which Michael has labored over his career, challenging the surveillance state, representation of draft resistors, criminal defense work challenging in various ways instances of prosecutorial overreach, litigating government regulation and prosecution of speech, challenging the government's use of the death penalty, and pressing the envelope of international human rights law in the United States and abroad. Now, I want to suggest, at the risk of prompting disagreement from the author, that this journey through the events and lessons of Michael's life in the law reads not as one book, but as at least three. And that one of the great pleasures of reading Sensing Injustice is the experience of moving among the different tones and modalities of these three different works compressed into a single volume. So one of the books that Sensing Injustice is, I think, is personal memoir, as Karen said, a coming of age story if you will. We learn of Michael's family history in California and beyond, of his childhood spent voraciously reading and bicycling around the Los Angeles suburbs and developing his dramatic gifts. We meet his family, in particular the single working women who raised him, his union organizer father, Chuck, who Michael lost, first to divorce and then to an early death, but not before Chuck advised 15-year-old Mike, presciently, to be a lawyer like Clarence Darrow for the people. We see Michael as a Berkeley undergrad and law student in the foment of the 1960s, literally finding his voice at the college radio station and finding it more figuratively in his journey in and out of the Navy Reserves, his work challenging loyalty oaths and representing leaders in the free speech movement, and the deep historical dives that he pursued in his very earliest legal scholarship that would be repeated in his later works. We watch him grapple personally with the toxic combination of government overreach and official timidity, combination he'll battle for his entire career, when his clerkship with Justice William Brennan was withdrawn on account of official distortion and mendacity about those same Berkeley activities. We see Michael dust himself off from that, and we meet his great mentor, Ed Williams, founding partner of what would become the Williams and Connolly law firm in Washington, D.C. And we watch Michael absorb the craft of advocacy at Williams & Lee, eventually to chafe at the constraints of firm life and launch his own prodigious law practice, in which he would be free, or as free as finances and family allow, to choose cases with meaning, cases that activated his sense of injustice. This book is a story of Michael seeking, finding, and honing his quite singular voice in the law. But in Sensing Injustice, I read a second book as well. I'll call it the law school text Michael wishes he had been assigned years at Berkeley, where he was, on his critical account, shown all branches and no roots. We learn a lot of law, but in a distinctive way. As we explore with Michael the various issues that have driven him in his career, meet the clients whose stories he has aimed to tell, and the prosecutors and judges that he has in some mix challenged, managed, and educated, we see cases not as isolated moments of litigation, but as connected to a holistic understanding, Michael's holistic understanding of law's history, structure, and progress. In journeying with Michael through his development of the Selective Service Law Reporter and his representation of draft resistors, we learn not just of the applicable law governing the cases, but of the history of conscription, the evolution of an increasingly arbitrary and lawless administrative apparatus dictating the fate of young American men, and the racist consequences of its operation. When we journey with Michael to Pittsburgh to represent steel workers challenging agreements entered into by their union leadership, we engage not only with the applicable provisions of the Landrum-Griffin Act, but with the history of American labor and workers' rights and the interplay of litigation with labor movement organizing. I could go on in case after case, from United States versus Alderman to the Chicago 8 to the Pinochet case and all points in between. Michael conveys his distinctive gift for situating present legal disputes in broader legal historical context. And in doing so, he connects the events of the book not only to each other through the continuity of his determination to challenge government impunity and the stifling of expression however it occurs, but also to a larger historical arc of the law's role in delimiting state authority. Finally, Sensing Injustice is yet a third book, a self-help book of sorts, with, I think, an intended audience of law students and young lawyers, aspiring to a life and a career of consequence. At times, Michael pauses narrative, breaking the fourth wall in a way, to distill and impart concrete lessons from his experiences. And then also, some accumulated wisdom emerges more gradually and implicitly over the course of the book. Here are a few pieces of advice I got from Michael that I would have liked to have had earlier in my career. Make sure your case tells a story. a story of your client and a story of the law. Be wary of judicial and prosecutorial ego, but know that there are people in the law with both power and conscience. Trust the capacity of jurors to learn and change and dispense justice. Decide what you want and ask for it. Don't mistake lawyering for movement work, but don't forget about the movement either. Believe that one case at a time can, over time, make a difference. And bring others along on your journey and remember their contributions to it with graciousness and gratitude, as Michael does so often throughout the book, recognizing many of the people who've gathered with us today. Speaking personally, I myself had the great pleasure of spending a brief time alongside Michael when I was one of the many law students of which he speaks in the book, working with him in the trenches. As Karen said, my chance came in defense of Lynn Stewart, the last trial of which Michael writes in the book, and one that, to an improbable degree, encapsulated in a single case all the themes of Michael's career to that point. Lynn was a New York City criminal defense lawyer, a National Lawyers Guild member, and known for her representation of political dissidents. Among Lynn's clients was Sheikh Omar Abdulrahman, also known as the Blind Sheikh, convicted for his role in the first World Trade Center bombing. In 2002, in the heady post 9/11 days when the sound of helicopters made New Yorkers anxious and Muslim men were being disappeared on material witness warrants, Lynn was indicted for a range of crimes, including conspiracy to provide material support to a terrorist organization, all premised on words she had spoken and services she had rendered in the course of providing representation to Abdul Rahman. Now, myself, as a progressive law student, hoping to embark on a career litigating on behalf of causes that are inconvenient to the government, I took the prosecution not only as a tremendous assault on freedom of expression and the right to counsel, but as a personal threat to my chosen path in the law. It was therefore a tremendous honor to be drafted by Michael to help beat that back. And I still have vivid memories of working away in my apartment on 105th Street until the wee hours of the morning, trying to master First Amendment law forged in many of the very cases Michael discusses in this book. The Benjamin Spot case, Brandenburg versus Ohio, the Dominic Gentili case that he argued before the Supreme Court. And I retain everlasting gratitude for the graciousness Michael showed me in allowing me to run with substantial pieces of the motion to dismiss Lynn's first indictment. And we won that motion. But a second indictment would follow, and Lynn was ultimately convicted in a trial in which, as Michael tells it in the book, the court refused Lynn's request to be severed from her significantly more deeply inculpated co-defendants, allowed by the government over defense objection to regale the jury with video of Osama bin Laden and evidence of terror attacks to which Lynn had no demonstrated connection, all over the course of 9 months in a courthouse blocks from the site of the September 11th terror attacks. Lynn received a 10-year sentence and died of cancer in 2017, shortly after being granted compassionate release from federal prison. My experience working on Lynn's case was, I think, something like Michael's in the early days of his work with Ed Williams. I emerged from the experience an infinitely more capable and confident lawyer, encouraged by Michael's example of forging principled conviction with lawyering at the very highest level of the craft. And like Michael's time with Ed, I got a couple fancy dinners and very nice glasses of wine out of the deal as well. But I gather that Michael exited the experience significantly more battered. He gives much attention to presiding Judge Coltle in his account. And I wonder, in a moment of armchair psychology, which I'm risking here, whether this is because Michael was disappointed that Judge Coltle's performance was another instance of official timidity in the face of government overreach, rather than something more noble. But I think that in concluding his account of his courtroom work with this quite difficult experience of loss, Michael reminds us that battling against injustice doesn't often look like what he absorbed in the movies and adventure books he avidly consumed in his youth. It is not all swashbuckling and riding off into the sunset, however much Michael has swashbuckled and ridden off into the sunset in his career. Rather, heroism in this work is manifest in the commitment to stand by the client, tell their story, to do your damnedest to find those crevices in the law that can be carved just a little bit wider to vindicate their struggle, and to journey with them wherever the reforged path of the law leads. Thank you for the book, Michael, and thank you for your work.
Jennifer, Roxanne.
Thank you, Karen. And many thanks to the Rappaport Center for Human Rights and Justice for hosting this event, and founder and co-director Karen Engel for organizing it. And especially to Michael for his lifelong advocacy and activism, and for this brilliant book. I'm a historian, not a lawyer, but reading this remarkable book, I found the timeline of my own activism and learned about the important work of Michael Tigar and other lawyers in shaping it. Professor Tigar begins his book in November 1969, when he stood before the US Supreme Court pleading an anti-war resistors case. Tigar was 27 years old, a member of the bar for only 2 years, but he had already worked on draft cases and published a book on draft law. This was a moment when he realized the limitations of the law in achieving justice. It is also the first time I heard about the firebrand movement lawyer, Michael Tigar. As a young anti-war, anti-apartheid, anti-imperialist militant, also involved in building the women's liberation movement at the time, I had little trust in the law or lawyers. But Michael Tigar seemed different than the stereotype I had conjured. It was clear that this man really cared and was a great asset to our movement. Draft resistance was the linchpin of the anti-war movement. As he writes, the heady glory days of the powerful civil rights movement in the South of the early 1960s that had won considerable popular support and legislative victories had turned to a darker time by 1969. The seemingly endless US war in Vietnam and the Nixon era of government repression, illegal surveillance, even a sense of desperation about ever being able to end the war. Although massive student protests, along with women's peace groups against the war, began in 1964, by 1969, with 500,000 troops in Vietnam, only 19% of the population opposed the war. And by 1969, Tigar tells us 9.7% of all federal criminal prosecutions were draft resistant prosecutions. Tigar was representing David Gutnick, who had participated in an anti-war, anti-draft demonstration in October 1967. I'm told that David is in the audience, and I want to thank him for his courage and contribution to the anti-war, anti-imperialist movement. He had not received a draft notification, but during the demonstration, he stood in front of a US Marshal in front of the Minneapolis Federal Building and dropped his registration certificate and notice of classification at the marshal's feet. Along with the Selective Service documents, he included a statement expressing his opposition to the Vietnam War and to conscription. 2 months later, Gutnick received a delinquency notice from Selective Service, and soon after, he received an order to report for priority induction, ordering him for military service ahead of his time. He refused to submit to induction into the armed services and was prosecuted, convicted, and sentenced to prison. By then, Michael Tigar writes, 30,000 young men turned in, threw away, or destroyed their draft cards. They all had been ordered to report for induction or face prison if they refused. 3,000 had been prosecuted and convicted and imprisoned already. Tigar writes that David's case and his argument provided a textbook example of how much we can and cannot expect from the advocates, the law, the courts, and all the trappings of what is called justice. He would not argue what he knew to be the fact that the draft system was itself unconstitutional, nor that the war in Vietnam was unlawful under United States and international law, arguments he had made in the past. But by 1969, courts, including the Supreme Court, had refused to even take it seriously, such an argument. He realized that to make that argument in this case would have been a pointless distraction. David wanted to avoid jail and be free to continue organizing. Plus, the effect of winning would free 3,000 other draft resistors and forestall the impending prosecutions of more than 30,000 others, and to shore up the activities of those millions engaged in protesting the war. This reality did not stop Tigar's fight for justice as he went on to decades of cases in the United States. He writes that David Gutnick and thousands of other young men refused to accept as inevitable and right the decision to send them to war. They saw the injustice of it and they took control of their own circumstances and resisted. Tigar goes on to turn that resistance from an act of individual courage into a process of social change. Many of them banded together. They understood that in the judicial system into which their resistance thrust them, we were not going to end the Vietnam War. The Supreme Court victory was narrow, but when thousands of young men avoided prison, it served a purpose. Tigar defended many more draft resistors and anti-war protesters, the Chicago 7, as well as Angela Davis and other political prisoners. But unlike many of the civil rights lawyers of the 1960s and 1970s, Tigar at the same time learned international law, especially the international law of human rights, which goes far beyond the US regimen of civil rights, in that international law includes social and economic rights, the human right to housing, healthcare, employment. Tigar was well aware of however, the limitations of human rights law. As the United States administrations claimed their military and other interventions were carried out in the name of human rights and democratic rights, as well as not acknowledging social and economic rights. Tigar writes that in the mid-1970s, he was propelled into a more direct part in the human rights struggles by a terrible event. This was in the wake of the 1973 military coup in Chile led by General Augusto Pinochet that was followed by murder, torture, and disappearances. The exiled Chilean ambassador to the United States, Orlando Letelier, was a leader in the struggle to restore democracy to Chile, but was murdered in a car bomb in 1976, clearly the work of the Chilean coup regime through exiled anti-Castro Cuban agents, which was confirmed by the FBI in 1978. Michael and a colleague drew up a civil complaint on behalf of the Orlando family. The suit was strangely controversial, but they did win the case. Tigar continued to be involved with cases regarding Chile and Pinochet until his demise. In the 1980s, Tigar joined a group of US lawyers that trained Black lawyers in South Africa to represent people in civil cases, discrimination cases, and political trials. He also traveled around the country observing the restrictions of the apartheid regime. He returned after liberation in 1990 when African National Congress lawyers were working on the new constitution. 99 of 100 judges on higher courts were white and 99% were men. And due to the agreements, it couldn't be changed. So Tigar and others suggested that a separate constitutional court be established with all new judges, which was adopted. In the ensuing decades, as the ANC solidified its political authority, Tigar observed the creeping neoliberal economic policies that developed, reflecting that the dialectic of history includes an interpenetration of opposites, by which old forms and attitudes persist, even after fundamental change. An important insight that we all need to keep in mind as we struggle constantly to change this country. So thank you again, Michael, and thank all of you for being with us today.
So much, Roxanne. Judge?
Hey, well, I appreciate the opportunity to say a word about Michael and this wonderful book that he has written. He is a force. I have to say that there's some things that out there in the world of individual rights, some short statements that capture us as an idea, a few words. One of them, which is the Human Rights Convention, that says that every child should have a name. And when I think about that, sometimes it crosses my mind that really, in so many ways, has a wide sweep to it. And in so many ways, Tigar's work also has this wide sweep. Michael has a gift. And as I sometimes tell my young clerks sometimes who are awfully bright and able, that to those that much is given, much is expected. And Mike has and continues to discharge that obligation. He has taken the ball from the handoff of Ed Williams, one of the great trial lawyers, and taken it on to another dimension. He's done it with great heart and passion, but he has stayed always within the rules of the game, so to speak. He has a respect for the Constitution. I say that at the outset because when I will turn to 3 cases and briefly mention those, because in some ways they lift up a lot of his range of ability, etc. But let me first make this observation about the skills that it takes to do what he does. I have been in one courtroom or another for the last 50 years. trial courts, including military courts as well. And I'll revert back to that.
I need help. We can pull the sofa up. Here, pick up your phone. 1, 2, 3.
What
It's
happens?
sitting in her mouth. Oh, what?
Someone's not on mute.
They are now. What I want to describe for you is a skill that I think that he has, and that is I can tell you what it is by describing it this way, I think. And lawyers either have this or they don't. But when you are tested for color vision, you go into the doctor's office and there's a big board with 1,000 pixels up there. And if you can see the color blue, then it tells you that what your vision is, or green, etc. But you're looking at it 1,000 pixels. When a lawyer looks at an event, a series of events, etc., there are facts running all over the place. There are 1,000 pixels out there. And some have the creative ability to see in those pixels a narrative, a story that can be told consistent with a law that furthers his client's cause, and in this case, furthers the greater cause itself. That is a gift, and Michael has it. Steven Spielberg has it. That it's the same type of skill as to visualize what's out there, a complete mess to other eyes, and how they will play out and be pulled together to advance a cause. That is a signal skill. I turned to the light on 3 cases to illustrate that. The first I will turn to his defense of Terry Nichols, one of the bombers in the allegedly in the Murrah Federal Courthouse building in Oklahoma City. This struck right at the heart of the issue. Murray was one of the leading judges in the country. I had the pleasure to argue one case before him. He was a tremendous man. What happens, but they had built a large courthouse there, emblematic of the new courthouse, whatever, and it was taken down by a bomb with the death of 167 people. And then what happens very quickly is that the concerns were about who will represent this fellow Nichols. The other fellow, McVeigh, had retained counsel, and the word went out to try to locate those. And ultimately, it centered very quickly upon Michael. And he took that task on, a huge task itself. There were so many victories along the way, the small victories, the little things that add up to the total in terms of how that case came to be. The bottom line was that he took a case that was not indefensible in some respects and saved the man's life. His co-defendant, represented by private counsel, was convicted and ultimately executed. Now, how did that come about, and what is the large significance of that case other than it's a great victory by a very powerful and strong lawyer? Well, what happens in this case is that Michael really takes to a new level the process of defenses in capital cases. And here where he is one of the many areas in which he has made a signal contribution. Our law of capital punishment is tortured and difficult. It is particularly difficult to administer in a context of dual federalism, where we have the federal, we express concerns over review of state activities and state judges and judicial proceedings, etc., which end up in many ways shielding very poor performances in state courts. This was a federal prosecution that did not have that initial difficulty. But it also demonstrated to the world that when the case is well tried, that indeed its long histories that usually flow from those cases is much shorter. What Michael did in that case was to demonstrate to that jury not only his client's involvement, but how he became engaged. He was not the one that set the bomb, but he was connected to it, certainly by the government, etc. But ultimately persuaded them that even though you had this horrendous result, destruction of a major monument, 167 lives, and women and children in a care facility for the federal workers there in the building itself, this horrendous crime, that one more death is not going to solve the problem. And in that, one of the vivid images that one has from that trial is the moment when Michael refers to my brother. And of course, the prosecution did him a favor in making some reference to that, only to get the reply from Michael, which tell him the story from the Bible of my brother. What that communicated to the jury, that this is a person in another life, and to the larger legal scheme, what it did was to demonstrate the value and the importance of much more relaxed access in the trial to evidence of mitigation, a mitigation case, if you will. And that performance, and as I think has continued, along with Mike's teachings and schooling the lawyers as to how to develop those cases themselves. And it, in many ways, then it has made a significant contribution to capital punishment as it's administered in this country. I think that in many ways capital punishment is slipping away as we see that looking around the country and in other nations itself. But the reason that's happening is that I think you have now basically a floor plan, a scheme for how to try these cases. And they're now, the quality of the defense has been uplifted considerably, although it still remains deficient. So I point to that particular case as demonstrating his sense in the courtroom itself, his ability to communicate to 12 persons. I turn briefly then to the defense of Cesar Chavez's son, Fernando, in one of the conscientious objection cases itself. And this is another finer point that the story is well known with Cesar Chavez, this incredible figure, this incredible leader, and within failing health, and Fernando was down in San Jose in school and not particularly inclined to follow his father's organization efforts, etc. The farm workers. So he was called home by his mom and told that his dad was not feeling well, and so on and so forth. But what happens is that when Fernando is indicted for not stepping forward under the Selective Service Act, then Cesar comes to Mike and asks him to defend his son. And in preparation for that trial, he has it pretty well in hand, but he still wants to know his story. He wants to know the client's story and Fernando. And so sitting out by a motel pool, when he's in preparation, he talks to Fernando. And Fernando takes him back to when he visited with his father. And one has a sense that there's been some estrangement there, but his father takes him for a walk, and he tells his father he's concerned about this, and he doesn't want to do this, and he doesn't believe in this. But he goes out and he goes on this long walk with his father, and he has essentially an epiphany as his dad tells him his story of where he gains his strength, where he gains his faith to carry on to be the movement leader that he was. So sitting by the pool, that Mike asked him to tell the story. So he starts telling the story, and he sees that he's choking up, and he's not really able to tell too well. Mike stops him. Now, a lot of lawyers would not have done that. Because now it happened, one of the large failings of lawyers in those situations is that, and Mike saw this instantly and stopped him. If you tell the story and you keep retelling the story, then it becomes a monotone, and you lose the emotive, communicative power of that moment, which is so critical to this decision about the sincerity of this young man. So he stopped him. And he also had in his mind what he's going to do that. He knows his craft so well, and he'd done his homework. This judge will let trial judge will let the lawyer move around. We'll do that. And he then carefully moved to one end of the jury box, and when he put a question to Fernando on the stand, then the jury would look over to Mike for the question, and then back to the witness box. And as he told this story, he began to tell it with great emotion about his relationship with his father, et cetera, et cetera. And when he concluded with this direct examination, 8 of the jurors were teary-eyed. Now, that's a little small point to the way he stopped the thing, but my point about it is that Mike has the ability to quickly grasp the opportunities for persuasion, et cetera. So I cite that as one example of a trial performance, but it's also reflective of a larger understanding that he has, and that's one of his great strengths. I think he reads people well. I think he has a real insight into the human condition. You see some great writers that have that insight themselves. You read Dostoevsky and you see his insight. It presaged Freud. Mike has this insight, and with a combination of the heart and the mind that's there. Finally, I want to just briefly refer to a court martial. This jumped out at me because I spent the first 3 years as and I turned 21. I was in the courtroom trying courts martials for 3 years, and I know something about that experience. And this is the story of Major Meeks, Deborah Meeks, a major in the Army that was had charges filed against her in Texas at the air base with sodomy. And there was an officer to be tried would have a 9-person jury with a full colonel, abusive figure presiding. And that's a military courtroom. Now, I happen to think they are very real one, but it is a very different environment. Here you have a young, quote, Hartbrand, the reputation of, burner and all this kind of thing, progressive, coming into a military courtroom, military setting. She's fortunate she had Mike, but a lot of lawyers would counsel that's the last thing you need is a Mike Tigar going into a military courtroom itself. So what does Tigar do? This is now, 7 years before the Supreme Court decides that the statutes, that this regulation of vice privacy struck it down. But what he recognizes is that the way this is crafted, this prohibition against sex, is not limited to persons of opposite sex, but each of those people up there may very well be threatened by that. And only Michael will then go back to Cicero's famous defense of the general who's criticized, and that the military simply cannot be challenged. You cannot tolerate the challenge to them about made-up charges against them. From Roman times, that has been the military tradition, etc. There are other things about the trial that I could mention, but that again is Michael doing his thing, and what happens in this court martial, and believe me, it's not easy to win. Take a case from a general court martial because they don't go to trial unless they think they've got a lot on hand. And those officers went out and thought, and what Michael had persuaded them was this was a challenge. This law, this application would reach right at you and right at the military, and you're now defending the tradition of the military, not guilty. So it jumped out at me that how many lawyers would have reached for Cicero's oration, even if they knew of it itself. I believe Major Meeks is here. The result of that was that they offered her basically to further promotion to lieutenant colonel, and she elected to retire at that point. But what was at stake was her whole career, her reputation, her retirement, it all is all on the table. And then it was Michael that in that point. So backing away for a moment, you see him operating in these different spheres, and you see the same talent being wielded out there. We were fortunate to have Mike. As I look at this book, as I told my colleagues here, that this is a textbook, but no law professor I know could write it, because it is a blend of the law in action and function. And I know something about trials, and this is a very powerful teaching tool, and it will become that for sure as people see and read about these things. Mike writes this, and he's quite aware that he is handing off to the future one of the obligations of the lawyer. And the final comment I'll make about him is that one of the things I knew about Mike, my work with him, was that he respected the court as an institution. He would operate within it to further the cause, even though that's frustrating at times, etc. When I got a call and asked him about this list of people that were possible appointment in Nichols' case, they gave me a list. They said, what are your top three? I said, Tiger, Tiger, Tiger. And he said, I think I got that. Why? And I said, because he's not only a highly skilled trial lawyer and effective, and that's what you really want, but he also is not a barn burner. He will play by the rules. Now understand, if the prosecution wants to play it in the press, he knows how to play the game too. But he will stay within the rules, and he will try the case straight up, and you will be proud of it. And I had no hesitation in making that recommendation, and I'm proud that he did exactly what we thought we would do, etc. So in some of I see a man of great talent who has fortunately been able to move along and do make a great contribution. Many people would have been floored by having a Supreme Court clerkship pulled out from under them. But somehow or another, between Justice Brennan and Ed Williams, they did not let this guy get away.
Thank you so much. That's Chickenbotham. And I think Tiger is a great segue to Roger Reeves.
I'm sorry.
I had to write my comments out partly because, I wanted to take after Michael Tigar and do the improvisational sort of opening argument sort of thing, but there were so many things I was thinking about, and as I was reading, what made it most difficult was trying to read towards having something to say, because I felt like I was in the sort of space of wisdom, and when you're in the space of wisdom, you just want to be quiet and listen. And so this was actually a true delight to read this book and to sort of, I get to have the sort of literary, the sort of disquisition, right, on this. And I find that to be fun because I think that Michael actually is really like his sort of sensibility is very much shaped. His sensibility of justice is very much shaped by his sensibility of literature, of aesthetics. And so here's my sort of take a little bit on that. You know, here we go. You are forgetting how punctuation might change the meaning, says Jacobus Tenbrook to his Speech 1A class at the University of California, Berkeley in the fall semester of 1958. Michael Tigar recollects this moment in his memoir, Sensing Injustice, a memoir that at once chronicles his coming to the field of law, his sense of justice, and his life in and out of the courts. However, this memoir also might serve as a journal of his reading life. From Diderot to Dryden, from Milton to Darrow, and well beyond that. Or the memoir might be a critique of law school pedagogy, as well as the pedagogy of teaching high school drama. One of my favorite moments is one in which Michael critiques Mr. Farley, his high school drama teacher, for not introducing the students to deeper issues of spousal abuse in Susan Glaspell's play Trifles or in Shakespeare's Taming of the Shrew. Michael's sense of the literary, of the aesthetic, is actually foundational to his sense of the law. Looking back, writes Michael, I consider such storytelling, here the storytelling he is discussing is that of O. Henry and Sir Arthur Conan Doyle, a good representation for representing people in all social conditions in life. This statement of the necessity of storytelling dovetails with what he offers earlier in his prologue. I have striven for a view of justice shaped by the needs of the clients. And for me, I heard, not by the needs of the state. I found this moment profound and underlined it several times because justice for Michael does not reside in a set of codes or conditions outside of the material and ephemeral realities of the people he serves. He understands justice to be a co-performance, a coordination, a bringing into relation. Thus, justice, redress, resides not outside of those harmed, but squarely with them, which for me seems to subvert and even contradict what I understand the reality of the courts and its decisions. I can't help but think of Michael's notion of justice as being in conversation with rhetorician and scholar Judith Butler's notion that redress, particularly for homophobia, sexism, and racism, should not reside solely in the courts, in the lap of the state, because often it is the state and its actors that are proliferating these injustices and injuries, i.e. the police and anti-Black racism, or even Goodnick v. United States. Or what occurs if the courts decide that no harm, no injury was committed? Does that mean no injury was actually committed? I'm not a lawyer, and I have at best a yeoman's understanding of the law and its discourse. So I will leave my critique of the courts there. However, in Michael's brief disquisition on his sense of justice, I hear something that moves beyond the American legal system's sense of justice, a sense of redress that centers its locus of control, not merely in a set of codes or in the courts, but in the people. In The State of Exception, Giorgio Agamben argues that this sort of centering is putting the people back into politics, that we live in a time of a peopleist politics. Citizen United versus Federal Election Commission is a great example. But again, I will leave the lawyering to the lawyers for now. I'm here to discuss the literary merits of Michael's work, which are substantive. In fact, I found it quite difficult to choose which one to talk about. For instance, within the first few pages of the prologue, you're confronted with a variety of literary techniques and formal pyrotechnics. For instance, Michael starts off quoting Supreme Court records in a long citational format that teaches the reader that this memoir will take on what we in the poetry field called documentary poetics. This quoting isn't done to merely produce evidence, but it's to shape the reading experience, to offer a multi-voicedness that plays with the volley of voices that make up legal discourse and justice. It reminds me of what the Russian formalist critic Mikhail Bakhtin calls heteroglossia. Heteroglossia is the notion that there are multiple discourses in conversation and sometimes contestation within a book. The speech of the narrator, the speech of the characters, the speech of the author. In Michael's book, we not only listen to and are provided with the speech of the narrator, Michael, the speech of the characters, and the speech of the author, who is also Michael, but we also get quotes from Dryden and Milton's poetry, witticisms from a letter exchanged with Gore Vidal, show tunes his aunt wrote, Great Depression protest songs, court testimony, and record. Michael's book literally gives us the vocal range of the American landscape. It truly is a representation of people in all social conditions of life. A literary scholar could have a field day with this memoir, thinking through the discursive citational practices, their political and aesthetic ramifications on the reader, what they enact. And if I had more time, I might give such a reading. However, I want to point out something that transfixed me and meant something to me greatly. It might seem quite small and of little importance to others, but it leapt out to my eye as a poet. It was Michael's use of anaphora in the prologue. Anaphora, for those who probably have never heard this term, is a repetition of the same word or phrase at the beginning of a line of a poem, in this case, at the beginning of a paragraph. Here's an example from Whitman's Song of Myself. Please forgive the length of the quote, but I'm a poet, so what can I say? And I would think Michael would forgive me for reading a little Whitman here. This is from section 2 of Song of Myself. I've tried to condense it. Loaf with me on the grass, loose the stop from your throat. Not words, not music or rhyme I want, not custom or lecture, not even the best, only the lull I like, the hum of your velvet voice. I mind how once we lay such a transparent summer morning, how you settled your head athwart my hips and gently turned over upon me, and parted the shirt from my bosom bone, and plunged your tongue to my bare stripped heart, and reached till you felt my beard, and reached till you held my feet, swiftly arose and spread around me the peace and knowledge that pass all the argument of the earth. And here's where the anaphora begins. And I know that the hand of God is the promise of my own. And I know that the Spirit of God is the brother of my own. And that all the men ever born are also my brothers, and the women my sisters and lovers, and that a kelson of the creation is love, and limitless are leaves stiff or drooping in the fields, and brown ants in the little wells beneath them, and mossy scabs of the worm fence, heaped stones, elder, mullein, and pokeweed. We get to the problem of Whitman. We can get to the problem of Whitman's disdainful politics surrounding race later, but you will notice the repetition of and, as if, and I know the hand of God is the promise of my own, and I know that the Spirit of God is the brother of my own. Michael has a similar Whitmanian moment in his prologue with the word this. Over 2 pages, Michael begins several paragraphs, sometimes one after the other, with this, hoping to define the dangling modifier he set out the page before when describing how he felt when he had reached the pinnacle of his career, only 2 years after getting out of law school, trying the Supreme Court case, Gutnick versus v. the United States. 50 years after that November day, writes Michael, I am moved to deconstruct the thought. It can't be better than this. In this moment of what a philologist or scholar of poetry might call correctio, Michael performs the self-reflexive, intertextual move of being in conversation with his own text as a form of revision. This moment of revision allows him to perform his deconstruction that feels at once postmodern and quite humble. Humble in that he seeks to query his useful assertion, postmodern in that he drives a wedge into an opaque statement and tests its veracity. He queries the God of his youth, putting those youthful pronouncements on trial. It's almost a kinder, gentler killing of the author. In this case, the author is the younger version of the narrator. But more so, the repetition of this creates a type of chorus, which offers a type of ritualistic return to the original phrase, the original pronouncement, and ironically moves us away from it simultaneously through expansion via his meditation on what the hell he meant. Repetition, particularly this sort of ritualistic repetition, breaks the reader away from time, defies time, offering us only the present of the text. I don't want to get into the weeds of lyric theory, but I do want to highlight the effect of repetition of this, and the repetition that this puts us in the time of the narrative, of the memoir. In other words, he's taking us out of the time of the world of the pandemic, the world of our busy lives, and putting us in the memoir. This sort of staging creates the opportunity for what is known as a lyric now. This lyric now creates an opportunity for transformation. It is the logic of a spell, which is the logic of cooking. If I put these ingredients together, flour, sugar, egg, for example, under the proper conditions, baking time and heat, we will have a cake at the end of it. That's a spell. That's magic. That's the courtroom where lawyers volley language back and forth, hoping to cause justice to come down out of the sky. In this case, the cake Michael is baking for us is sensing justice. He wants us to come out on the other side of this memoir, not merely witnessing a life dedicated to justice, but ourselves ready to commit to justice, to action. In this way, I find Michael's memoir reminding me of something the late poet Adrienne Rich wrote in a poem called Dreamwood. She wrote, "Poetry isn't revolution, but a way of knowing why it must come." In reading Michael's memoir, I feel a similar call, a similar announcement. The memoir isn't justice, but it's a way of knowing why it must come. Thank you.
Wow. Thank you so much, Roger. And thank you to all of the commentators. I think there's still a few things that weren't covered in the book, but not many. And so now I guess we'll turn it over to whichever author is still alive and would like to talk. Michael, do you want to say some words?
I only want to say, first I want to say thank you. I feel like a guy that woke up at his funeral, but there you go. And I know that it's not my funeral, because if it were, the dean would be saying, "Oh, and by the way, I want to talk a little about biannual giving." But there we go. Now, the first thing I want to say is that litigation and involvement with the movement for change is a team sport. And I need to address an injustice, because shortly after being appointed to represent Terry Nichols, I reached out to Ron Woods, who was a graduate of the University of Texas Law School. And that partnership endured all during the succeeding years and during the trial. And if you read this kind of antiphony between my literary or argumentative or rhetorical approach and Ron's approach to the issues that we had before the judge and then trying the case to the jury, then and only then can you derive a complete picture of this, rangy lefty guy, that being me, and this former FBI agent, former United States attorney, who brought to bear those very skills and that credibility with this jury, and whose opening statement began with the brilliant assertion, "Members of the jury, the FBI did a wonderful job investigating this case for a day and a half." And then went on to build a narrative structure. So it is a team sport. The second group of folks I want to talk about, I see Debbie Meeks there. Hi, how are you? And Dave Goodconnect, as we've been writing back and forth about these connections, the connections between the anti-war movement and the movement to combat racism, and the way in which lawyers don't make things. They come upon a scene that is shaped by people engaged in a movement for change. So that, for example, when the Rodney King prosecution happens, there's a playbook about Black supermen and cops just doing their job. But the people that have been marching in the streets and talking have now liberated jurors from those constraints, free to see that the officer who approaches the man on the ground is not just doing his job in a racially neutral way, but may have another intent entirely. And that all of the bullshit about the police manual, including the myth of the Black Superman, he's ready to rise up at any minute unless you keep your knee on his neck, which was also a part of the Rodney King defense, simply isn't so. So is this interrelationship, and I'm just glad to be a part of it. Next, thank you all for focusing on the parts of the book that are not just about me. Fran Lebowitz said a book should be a door and not a mirror, and I hope accomplished a little bit of that. And so, you know, all the other names, we got Rob Owen, who taught me a little bit about how to argue in capital cases. Thank you, Ron. I didn't learn it all. I see Michael Churgan. I remember discussions with him. Juan Garces is there, Robin Martamutu, and so on. So thanks. Now, a word about this book. I'm so glad that people talked about this book in terms of what it might say to people involved in the movement for change, but then to lawyers and people that want to be lawyers. Because I thought about the title a lot, and it just seems to me that we're all today looking at people out there making change. We can sense injustice, and having sensed it, we can try to figure out what we ought to do about it. And if this book can make a contribution to that, well, I'm glad. I don't want to go on at enormous length, but I should say that I'm also glad to see that John Tigar, Elizabeth Tigar, and Dr. Catherine McQueen are here today, and that a part of this job of learning something as you go along is that those three people have tried to teach me a whole bunch of things, not with entire success, I must say, but they have vowed to keep on after it. And so I close with thinking about a walk that my son John and I had in Chrissy Park a few months ago in San Francisco, and he reminded me of that quote that's been used by a lot of folks. You must, it's at the end, only at the end of the day can you only, it's only at, what is it, only in the evening can you realize how splendid the day has been. There, I screwed that up. Even so, you screwed up Sophocles, for heaven's sake. Thank you all for coming out, and thanks to Karen Engel and Sarah Eliason for organizing this event and putting it all together. Thank you.
All right, so there's been a very active chat and going. So thank you all for contributing to that. We do have a few minutes left for people to ask questions, make comments. As I said, you're welcome to raise your virtual hands. You're welcome to put a question in the chat to everyone or to send it to me. Virginia Raymond noted that was a standing ovation, and absolutely, I'm standing.
Oh, good. Well,
it's hard to get that virtual, as well as the ums and the ahs and the laughs along the way that I'm sure a number of you know shared.
Let's see, there they are. Well, then if nobody's going to ask a question, I got to tell one more shout out then. Judge Nancy Atlas is on today, and we remember her, Jane and I, because it was the Atlas boys who insisted that we ride the Tower of Terror at Disney World 3 times. And the fact that Judge Atlas and Elizabeth and Jane and I survived that experience and have gone on to live our lives is a considerable tribute to everybody. Hello, Judge Atlas.
I actually do have a question.
You don't even need to raise your virtual.
I should be able to know how to do this. I'm like the age that I should know how to do this, but I don't know how to raise my virtual hand. So hi, this is my hand. So I have made it through most of your book, Dad. And my experience I don't have to explain it, but it's sort of on a smaller scale. And there's language in the psychological and therapeutic world, and the term is the transmission of intergenerational trauma, which is a very fancy way of saying if you don't learn from history, you are doomed to repeat it. And in reading your book, I guess this is sort of half rhetorical, but half a question. I wonder if you see your work as sort of progressively trying to break the cycles of injustice that I think all societies, all systems need to work towards doing, and how you thought about that.
Wow. Well, the most surprising thing about the research that I began to do in the book was about my father, who left our house when I was 4 or 5 and then died young. And he never talked about his work with the Machinists Union. And yet I found these primary sources that in 1937, when Lockheed recognized the Machinists Union as a bargaining agent for its employees and the war production was ramping up, a large number of African Americans were being hired in the aircraft factories up and down the coast. And my father, as leader of the Lockheed Local, was the only leader that told the Machinists Union, we are not going to obey the national constitution whites only clause. We are admitting African Americans into full union membership, something that he never talked about. And so, yes, I tried to study the lives of my parents and what was going on in that generation. I guess that's a product of just going to the library every day. So I hope the book is kind of imbued with, I hope, a sense of the possibility of progress and the involvement of everybody, and not just this class of legalists in making it. The deeper question that you ask is one that you and your sister and brother will have to answer. And that is, we're all, I'm all aware of the many, many imperfections in the process, but I look at the three of you and I say, damn, I won't take credit for that, but gee whiz, look at those kids, will you? So for whatever reason, that's the story.
Well, that, and I guess I was speaking more in how that the process of making change can be abstracted into global systems as well, so that your work as a lawyer is about sort of breaking these cycles within governments and legislations, and the progressive work of us making progress as a nation and a globe, so to speak.
Well, I get it. And
sorry.
No, this is, I think in the book I talk about this also, that this is what Martha Nussbaum was talking about, that we really don't have to have an argument about value judgments and de gustibus, blah, 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 and so on. The fact is, we can observe the human condition, and we can observe people's responses to what they perceive as injustices that are happening to them. And if we listen to that and become engaged with it, we will make the change. And the first and best example I ever encountered was February 1st, 1960, when a group of students said, gee, this Brown v. Board of Education has been around for almost 6 years, and there's nothing happening, except standing in the foyers as 100,000 racist lawyers, and they're keeping it from happening. So let's do something. And that was what moved me, because what it did was it falsified the premise that the lawyers had the tools to solve it all. And it called upon us to recognize where the power and the insight was. And then, by the way, into representing the people who were confronting authority in that way. We suddenly became, not students of the power to make an injunction against something, but a way of talking about, members of the jury. You got to let these people go. You're mute, Professor. Professor Engel is mute. There she is.
I saw that Virginia Raymond had her hand up, and I don't know if the hand just went down intentionally or not, but I wanted to give her an
Oh, and
opportunity.
I didn't, by the way, I also have to say, Robin Martimoto called me up one day and said, gee, I enjoyed being your student in Aix-en-Provence, and I enjoyed being a student at the University of Texas. How'd you like to get involved in a case? And 21 years later, there's a decision of the International Court of Justice, and it's still going on. So I just want to say, when you're volunteering for these things, you got to be careful. Because you'll get somebody like Robin, and there it'll be.
Anyone else? Questions, comments? Again, thank you all for writing in the chat.
Oh, it says David Vine asked the question, do I wish I had?
What do you wish
you had said in the book that you didn't have a chance to say? Okay, forget it.
Thank you, David.
Yeah.
Do you want to, I think that's for you, Michael.
Well, I hesitate. John Mage is there, and he's the one who, when the manuscript came in, said, oh my God, it's 500 pages. He said, how in the world are we going to get that out the door at a reasonable price? So I'm afraid to say that there's more that I wanted to put in that I didn't. So there.
Yeah, one thing I think.
It's Goldstein. If all of us could tell how important you've been in our lives and in the law and in the personal and cumulative experiences we've all had, the book would be 100-fold longer. Thank you, Michael.
Well, thank you, Jerry.
Yeah, we're going to look forward to the next edition, right?
Well, that's the thing. When I started to write a memoir, John Mage said, that's a hazardous undertaking, because you'll finish it and then it'll be like the Rolling Stones. It'll be just more and more farewell tour. And then you'll have to write another one. But I think that I would not step into a courtroom today to try a capital case. I'd be afraid that, maybe I'd make a mistake. I'm getting older. I think the last Court of Appeals case I argued, Sam Johnson was there, and we did okay, but I'm not tempted to do that again.
Do any of the speakers want to have a last? We're actually at 1:30. We did well.
We did.
Okay, I think I will pronounce this event officially, but only the event, not the conversation. So this event officially closed, and I will have another round of applause in a moment. I do want to say, I think if you're up for it, Michael, maybe we should just keep the video on for another 10 or 15 minutes if people just want to do what they were doing at the beginning and say hello, without any requirement whatsoever that anyone say.
I'll stick around, and people can just sound off or do whatever they want to do.
Okay. I really can't imagine having had, I mean, you all, I can't imagine a better group of people to talk about and to be here in celebration of this book. And I just love all the many different facets that came out of the book and the telling of it. And it obviously is a real feat that only you could write this book, Michael. And fortunately, a lot of us get to appreciate it and enjoy it. So please join me once again in thanking Michael, Jennifer Lauren, Roxanne Dunbar Ortiz, Patrick Higginbotham, and Roger Reeves.
Yes.
And we'll keep things rolling for anybody who wants to stay around. Wish we had champagne to offer.
Why?
Well,
Rappaport,
Karen
dinner
and
could have
Michael,
been
thank you so
offered.
much.
Get out to everyone.
It's 10:30 p.m. in Mauritius, and I'm going to retire. Thank you so much for everything. Thank you, Michael.
Thank you very much,
You are
Robin.
the
It's
best
good to see you.
humankind.
And Juan Garces, it's late where you are. Ouais, on a parlé aujourd'hui de la bataille permanente. Hein? Il perd, il gagne. Ouais.
Exactement.
Hey, Robin.
Voilà.
Hello, Robin. Hello, Juan.
Oh, hello, Jane. There they go. Let's see. 1, 2, 3. They're all doing. Who else do I see? I see Sam Johnson. I see Sam Johnson there. We won that 3-zip, didn't we?
Yes, sir. Yes, we did.
That was pretty good.
It was a tough panel.
That was a tough panel. And that's, it's this terrible thing about, I thought that I was not answering the judge's question, I was afraid I'd missing, but I think she just wanted to lay out her theory.
Yep. Are you sailing?
No, we sold our boat. We sold our place down in Oriental. We're prepared for new adventures. And, being 100 miles offshore, at 1 o'clock in the morning is not what an octogenarian should be doing, I think.
You look good.
Well, thank you. Thank you. And there's Carol Soto, Meeks. Here they're all moving off. Karen, thank you again. Thank you again.
It was my
Come
pleasure.
to Austin
Oh,
sometime.
and there's Dave Goodconnect. Hello, David.
That's really great to see you.
It is great to see you. And David, David sent me an email pointing out the relationship between the movement against racism and the anti-war movement at several historical conjunctions, as it were. And this is important. So, folks, it's almost as though this is an exhibit. We freed David Goodconnect.
Yeah, I'm just 7 years younger than Michael, and the year of my birth is when leaders of the Black community, in the face of the proposed new draft that was going to maintain segregated armed forces as in World War II, Bayard Rustin and A. Philip Randolph told the committee, well, if you don't desegregate the military, we are going to encourage all young Black men to refuse to register for your draft. And this got their attention. And within a week, Truman signed the order to integrate the armed forces.
Yep. David Goodconnect is also the guy who, remarking on the draft lottery, said, if you refuse to play the lottery, there's no way you can lose.
Yeah, we wrote a booklet that had about 20,000 copies in 1970 that was actually titled, Check Out the Odds. If you're not in the lottery, your number can't come up. So I personally believe that if they seriously propose women being subject to the draft, we should promptly launch a massive civil disobedience campaign to prevent their proposed draft from ever working. This is what we did before, and we can do it again.
Well, there's the message for the day. Oh, and there's Dr. McQueen. All right.
Hello, Dad.
Hello, Dr. Katie. Dr. Catherine McQueen is in her bicycling outfit. She's doing these long rides. You should look up Dr. McQueen's work. You can get that through the Texas Criminal Defense Lawyers Association. She has testified as a mitigation witness in capital cases. very effectively about the impact of substance abuse on young people. And you see Aura Newland there. You want to look Aura Newland up. She's done so much important work about the Japanese incarceration. She's on the board of the Heart Mountain Camp in Wyoming. We'll keep calling them out here.
Great to see you, Michael. Thank you.
Well, oh, and hello, Mark Smith. He's going to try to get me to do something. Is this? Yes, there we are.
Mike, I just want to say it is wonderful to hear all of these people talking about you. I remember our organization is one that does education, and Judge Higginbotham, who was leading the organization, decided it was time for us to get in the business of teaching about how to better represent clients who were accused in capital cases. And we put together an 8-day marathon program. And of course, the one person that Judge Higginbotham turned to lead that program was Mike Tigar. And it was, as people described it, this was 20 years ago, a life-changing experience for them. And you've been a life-changing force for a great many people. Thank you.
Well, that program illustrated the value of shaking up lawyers' perceptions of how they ought to proceed. That she should not be like the artisan who said he's got 20 years of experience when really he's got 1 year of experience 20 times.
Well, let me tell you, at the end of about a 2-week session up there with intense all day long in evening sessions, and Mike talking with these lawyers and walking through and helping them. So many of these lawyers are practicing out of the shopping center. They don't have the resources to support them, et cetera, and they didn't have this kind of exposure. When they handed out the certificates, there were tears in the eyes of a lot of those lawyers because they really genuinely thought that they had been helped, and they had, because it was just a remarkable exercise. Because Mike, he would do things like sit down with someone and say, okay, I take him off what he call a locker room, and he would say, okay, now I'm your co-counsel. Give me the last 5 minutes of your closing argument. Oh, well, what about this? What about that? Have you considered this? You get these papers here, et cetera, et cetera, et cetera. That kind of intense training goes so far. Jordan Steiker's here, his work and his sister's work, and Mike's work has had a large impact. And a lot of it just goes right back to Michael coming right out there. You came right over and over. I guess you coming from Duke at that point, over in that area, all the way to Dallas to Hoforth. And Mark was the head of that. And Mark was our president and been there for how many years now, Mark? But sometimes the Yaleys overcome it.
Well, and I see Nancy Hollander is here as well, unless that's Jodie Foster hanging behind there. That's a great, hello, Nancy Hollander. That's a great film, and those are great issues. The Mauritanian, and there is a real live Nancy Hollander who real live does that work. Thank you for being here.
Thank you, Michael, and I do hope everyone will see the movie, The Mauritanian, about what you can do when you're incarcerated for 15 years wrongly and you maintain your humor and dignity and humanity, which my client Mohamedou did. Thanks, Michael.
That was the, people asked those questions, and that was the thing that struck me about meeting with the ANC comrades in South Africa. You know, for 30 years, they'd lived in this system, and yet were every day involved in thinking of ways to make it change.
And Michael, think about with Nancy's client, he was never charged with anything. And we've still got, Nancy, how many of 40 people held
They're about
in Gitmo without charges.
Well, some of them have been charged. About a few of them have been charged, Jerry, but 6 of them were cleared for release and are still there. One for 10 years, been cleared for release for 10 years.
Yeah.
And another 25 have never been charged. A few have been charged, but they've only been charged in the military commission, which isn't really a court.
Right. Yeah. I don't want to be disrespectful, but after the wildfires in Australia and all the deaths of animals, how are they going to get enough kangaroos to staff those courts?
That is indeed a good question. We all had little kangaroo on our lapels, and everybody, I think, still does. I'm not sure if the military lawyers do, but the civilian lawyers do, and it probably didn't, the judge didn't appreciate it, I'm sure.
Well, Professor Engel, are we're free to go, or should we just hang around and tell lies to each other?
Well, I think that probably we should let folks get on with their day, but I loved the moment at the beginning.
By the way, this is
Just getting a chance to see each other, and hopefully we'll have another event on something that will bring you all in person.
Yes, thank you.
So it's really been terrific. So thank you all again.
Bye-bye.
Thank you.
Thank you.
Thank you.
Do you see coming to Austin in your future? Sharon, let me know if he comes to Austin.